Please be seated. I declare open the public hearing on the admissibility in the case of Georgia versus Russia 2. The case was lodged on 11th August 2008 with the court under Article 33 of the Convention by the government of Georgia and was accompanied by a request for an interim measure under Rule 39 of the Rules of Court. The application was allocated to the fifth section of the court pursuant to Rule 51, paragraph 1. On 12th August 2008, the President of the Court, acting as President of the Chamber, decided to apply Rule 39 and called upon both parties concerned to comply with their engagement under the Convention. The application of Rule 39 has since been prolonged several times. On 6 February 2009, the agent of the government of Georgia submitted the formal application to the registrar of the court. The application was communicated to the government of the Russian Federation on 27 March 2009. The government of the Russian Federation are represented by the representative Mr. Matushkin, Deputy Minister of Justice, and by barristers Mr. Swainston, QC, and Mr. Mendelssohn, QC, as well as Attorney at Law Mr. Ivanian, each assisted by their advisors. The government of Georgia is represented by Ms. Buryalyani, First Deputy Minister of Justice, and by the agent Mr. Meshkoradze, as well as by barrister Mr. Emerson, QC, each assisted by their advisors. I welcome the representatives in the name of the court. I would also like to welcome the delegation of judges from the Russian Federation, Finland, and France who are attending the hearing today. Having consulted the representatives of both governments, I have determined the order of addresses as follows. Mr. Matushkin and Mr. Swainston for the government of the Russian Federation will speak first, and then Ms. Buryalyani and Mr. Emerson for the government of Georgia.
Very much. Honorable judges, I would like to make a short introductory statement concerning the subject matter of the present case. First of all, let me know that had Georgia not violated the principle of the non-use of force in international relations enshrined in Article 2, Paragraph 4 of the United Nations Charter, there would have been no human rights violations in the territories of South Ossetia, Abkhazia, and Georgia proper at all. As regards the issue of control over occupied territory, it cannot be treated in abstracto. Evidently, South Ossetia and Abkhazia were separate parties to the armed conflict. The level of control of the Russian Federation over the territories of South Ossetia and Abkhazia has never reached the threshold necessary to attribute to Russia the responsibility for the military forces, militia, or civilians of South Ossetia and Abkhazia. There was a total lack of elements required for the qualification of such control as effective and overall. Thus, the Russian Federation considered that Georgia's application to the court to be inadmissible for the lack of jurisdiction of the Russian Federation over South Ossetia and Abkhazia within the meaning of Article 1 of the Convention. The Russian Federation had to give a lawful and strictly limited response to an unlawful, well-planned, intentional armed attack of Georgia of 7th August 2008. The fact that the Georgian attack of 7th August 2008 on Tskhinvali was planned in advance is confirmed by, inter alia, the report of 30 September 2009 of the Independent International Fact-Finding Mission on the Conflict of Georgia. The attack of Georgian armed forces against the foreign peacekeepers clearly amounted to an international conflict within the meaning of Article 2, common to all the Geneva Conventions of 12 August 1949 and Article 1 of the Additional Protocol Number 1 of 8 June 1977. The intervention of Russian Federation armed forces was undertaken firstly for the protection of the Russian peacekeepers and nationals, fully recognized under public international law, and secondly, in furtherance of the Russian Federation's peacekeeping obligations to prevent conflict escalation and further casualties. The actions of the Russian Federation forces were limited to eliminating a clear and existing threat posed by the Georgian armed forces to the Russian peacekeepers and nationals in South Ossetia and Abkhazia. The intervention ceased as soon as the threat to peacekeepers and civilians had been neutralized. Thus, the use of force by the Russian Federation in South Ossetia, Abkhazia, and in the neighboring Georgian territory was in full compliance with the international law of war. I would also like to stress that the Russian Federation has discharged in full its obligations under the Medvedev-Sarkozy Plan of 12 August 2008, with the additional items of the 8th September 2008. And now, let me give the floor to Sir Michael Svensson, who will proceed with a detailed presentation on behalf of the Russian Federation. Thank you.
May it please the Court, there have been extensive written submissions, and I will not repeat ours now. I would like to deal with 5 matters orally. They are, first, the Al-Skeini decision and effective control. Secondly, the issue of state support as a basis for jurisdiction. Thirdly, the relationship between convention law and international humanitarian law. Fourthly, the evidential test to be applied at this stage. And finally, the threshold objection of failure to exhaust domestic remedies. I will focus mainly on the situation in South Ossetia, where lies the main burden of Georgia's complaint, but the relevant points of principle apply equally in relation to Abkhazia. First, Al-Skeini. Georgia will no doubt try to rely upon the decision of the Grand Chamber in Al-Skeini, which came out after written submissions in this case went in. Reliance by Georgia on Al-Skeini would in our submission be misplaced, and it's appropriate to spend a little time explaining why. This court will be familiar with the Al-Skeini decision. It concerned the death of a number of Iraqi civilians at the hands of British armed forces in southern Iraq. The Grand Chamber held that the deaths occurred within the jurisdiction of the United Kingdom for the purposes of Article 1 of the Convention. There are a number of points to make about Al-Skeini. To start with, it was a very different case from this case in terms of its facts and reasoning. As recognized in the judgment itself, it was an exceptional case. The United Kingdom and its coalition partners had displaced the previous Iraqi government, and that was the purpose of their intervention. They then committed themselves to establishing a new government and civil order in Iraq, and they set themselves up as the government of Iraq under the title of the Coalition Provisional Authority. The Coalition Provisional Authority then delegated the administration of southern Iraq to British forces. There was no other civil government in the areas of Iraq in issue. Convention state encompassing the relevant territory. However, when Russian forces intervened, the Georgian army was deliberately shelling, and in the hills above Skinvali, in the firing positions of Georgian troops. And when you do, you see swathes of red roofs, red roof tiles, which are new. come under unprovoked attack. They entered South Ossetia on the 8th of August 2008 and began their withdrawal on the 20th of August 2008. The effect of existing government or to establish a new one. There were functioning governments in South Ossetia and Abkhazia. Georgia complains, but in its letter to Human Rights Watch, dated the 3rd of December 2008, Georgia acknowledged that about 5,000 of its police officers participated in the conflict to the conflict areas. It follows that their exclusion was part of Georgia's retreat and involved no usurpation of any civil function by the Russian Federation. In short, in this case, there was no annexation beyond the commitments of the signatory states under the Convention. As to the commitments of states